Hello, good morning, or excuse me, good afternoon now. It is noon. We're going to give another minute or two for some people to shuffle in. Download the latest version of Zoom as always, right? Perfect. We're going to go ahead and get started. Hello, everybody. My name is Andrew Ky. I am the past president of the EBPA. I'm filling in this morning as the Toastmaster as we have a few folks out for different reasons. So welcome. Thank you for joining us today. We welcome Andy Haynes back. Today's session provides several continuing education opportunities, Missouri and Kansas insurance CE credit, 1 hour of SHRM credit, and 1.2 hours of Missouri CLE credit. So we will be filing that on your behalf. So if you have any questions around that, let us know. Today's presentation is Fiduciary Duties for Insurance and Employers Plan Service Providers. Andy's covering fiduciary responsibilities, legal obligations of insurance professionals, and more. Andy's the president of Haynes Benefits, an employee benefits law firm here in Kansas City. He's the author of two EBI of America manuals and a fellow of the American College of, he's the author of two Employee Benefit Institute of America manuals. He spent thousands of hours across the country delivering topics and conversations such as this. He is a proud graduate of the University of Missouri Columbia and has a law degree from Emory University. Very fortunate to have Andy back here today. Welcome, Andy.
Well, thanks, Andrew. Today we're going to be talking about ERISA fiduciary duties. As most often we talk about them as they apply to plans, but today we're going to talk about them as they apply to plan service providers. And by plan service providers, I'm going to be talking about pretty much everybody that's on the call today. But as we jump into this, I want to start with our acronym, because all these fiduciary duties are going to come from ERISA. So the first thing I want to do is talk about that acronym. And in this case, the acronym has a lot of both obvious and hidden meaning. So the E in ERISA stands for employee, and you're saying, duh, but it means something bigger than that. What this means is that the statute is designed to protect the interest of the employee. The DOL has very little interest in protecting employers and in protecting service providers. What this means for all of us is, unless we dot every I and cross every T and double check that we do so, if there's a dispute between the employee and the plan or between the employee and the service provider, the employee is going to win. It puts a very hard duty on all the rest of us to make sure we do what's right. The next three initials in the acronym are retirement income security. Retirement income means something different for today for us. The original ERISA was about 85% on pension plans. A very small portion of it dealt with health plans. So ERISA was really a statute to regulate pension plans. In 1974, when it came about, there was a lot of embezzlement and theft and mishandling of employees' savings in the retirement plans. And there were rules that allowed employers to have such things as 10-year cliff vesting, which meant if you left the company anywhere before 10 years, your balance in the pension plan was zero. And then there were some key cases, including the Studebaker case, which I won't go into all the details on that, but that brought about this law. And I won't go into details of the Studebaker case, but if it's named after Studebaker car, you know it wasn't good. The S is for security, and that means that whether it's pension or health, we want to make the plans secure for individuals. And then the A gets us to act. Again, the statute came about in 1974, and there's a little interesting backstory. At that point in time, the country had been through a lot. Nixon had resigned due to Watergate scandals and such. Vice President Ford became President Ford, and the country was in a very turbulent phase in terms of relationship to the White House. President Ford wanted something big to get the country happy again, get the country excited again, and to do something for workers. He went to the House and Senate leadership and said, what can we do? What do you have that's ready to go or very ready to go? The House leader and the Senate leader said, well, we've got this statute called ERISA. We haven't been pushing it too hard, but we could get it dusted off pretty quickly and get it passed. And that's what happened. And that brought us ERISA in 1974. Uh-oh. So let's talk about the regulatory framework of ERISA and of plans. Our main statute's going to be ERISA that we're going to be talking about today, but health regulation in the U.S. is very layered. The IRS governs tax benefits of plans. The DOL regulates plan administration and fiduciary duties. Health and Human Services sets national policies and rules. CMS, which is within HHS, that stands for Center of Medicare and Medicaid Services, regulates under the Affordable Care Act. OCR, which is under CMS, which is under HHS. OCR stands for the Office of Civil Rights, and OCR enforces HIPAA. So for a field that is somewhat limited in terms of the number of folks involved in the administration, we have no shortage of regulators. Unlike many fields where you do something and you've got one regulator, here we have many, and we can add 50 more to that list because states license insurers and enforce plan laws, subject to ERISA preemption. But so we officially have 55 different regulatory agencies. So let's dig into now what is a fiduciary. It's a very, very key term. It comes from a Latin word, fiducia, which means trust. It's a person who has the duty and obligation to act for another under circumstances which engender total trust, good faith, and honesty. I often describe it like this. If I have my own funds and I invest them in a really cruddy investment and I lose my money, no one cares. It's my money. I messed it up. With a trust relationship, if you're holding other people's money in trust and you make a bad investment and you lose the money, you're liable. Under ERISA, you can be liable. That's where fiduciary comes from. A fiduciary is a person of trust, holding things in trust, having duties within that trust. So anyone who exercises discretion or control over plan administration or plan assets is a fiduciary. Look at those two key phrases, discretion or control over plan administration or plan assets. If you do that, you are a fiduciary. So who is a fiduciary? What jobs, what people, what identities are fiduciaries? There are really two general categories of fiduciaries. The first one's easier. The first one's really pretty easy. It's somebody who is a fiduciary by title, okay? And if we're going to use our Latin again, and every lawyer has to use a little bit of Latin to prove they're a lawyer, this is known as a de jure fiduciary. That means fiduciary by title. What titles make you a fiduciary? First off, it's plan sponsor. The plan sponsor is the entity that sponsors the plan, brings the plan into being, and has the ability to adopt and amend or terminate the plan. Most often, that's the employer. The employer establishes the plan. The employer works with the service providers on this call, develops plan documents. The employer signs the plan as the plan sponsor. Okay? And so we often refer to this kind of as employer slash plan sponsor. It can be another entity. It's a possible. But if we're talking about an employer plan or a single employer plan, the employer is going to be the plan sponsor, and they are a fiduciary for that. However, they're what we call a limited fiduciary. Their fiduciary duty is solely to adopt and amend, and if necessary, terminate the plan. In terms of plan administration, that duty is then downloaded onto the plan administrator. Here we're using a defined term. We're not talking about necessarily a claims administrator or an insurance administrator or any of that. We're using the ERISA terminology for the plan administrator. So the sponsor sponsors the plan, the administrator administers the plan. The sponsor has the limited duties I talked about in the preceding slide. The administrator has one duty and one duty only: absolutely everything. Everything that goes on in the operation of the plan is under the control of the administrator. Now you're thinking, well, wait, they're delegating duties to me as a broker. They're delegating duties to me as a TPA. They're delegating duties to me as a stop loss carrier. Yeah, they are. And there is a delegation. And the one to whom duties are delegated are also going to have responsibility, and we're going to talk about that later. But it doesn't matter who screws up. The plan administrator can be liable. They can be liable if the service provider doesn't have the assets to cover the liability. They can be liable if they didn't monitor the plan entity there. So whatever happens with that service provider, the plan administrator can be liable. Often we see documents where the plan administrator is not named. What if the document doesn't say the employer is the plan administrator? Well, ERISA fills in the blank. ERISA says that the employer becomes the plan administrator and the named fiduciary, which we're going to define here in just a moment. So if no one else is named, the employer itself becomes the plan administrator. Okay? So remember that. One duty, everything. Named fiduciary. This is also a specific title under ERISA. The named fiduciary has a couple of duties. The named fiduciary is the agent for service of process if there is a lawsuit. They're also the agent for service from the IRS or DOL or maybe state regulator if there are some annual documents that need to be filed. And so the notice on those documents will go to the named fiduciary. Often, the plan administrator and the named fiduciary are the same. In some cases, they will differ. Plan administrator might be the employer, it might be the employee benefits committee, might be another group, whereas agent for service or the named fiduciary might be the in-house general counsel, might be some other party. And usually you want an individual named as the named fiduciary for purpose of service. And then finally, our last fiduciary by title is the trustee. One of the requirements of ERISA is that plan assets must be held in trust. And so therefore, we must have a trustee. The trustee could be the Employee Benefits Committee. It might be a bank, which is hired to be a professional trustee. There are a number of ways that the trustee can be configured. But if we have plan assets, and we'll talk more about that later in the hour, if we have plan assets and plan administration, we need to have a trustee. So those are our fiduciaries by title. Again, they're easy to identify. Even if they're not listed, ERISA, as I said, fills in the blanks. Let's get to the trickier ones now. And that is the fiduciary by action, and Latin would be de facto fiduciary. Fiduciary by action. These are individuals or entities that are not named as a fiduciary, but become a fiduciary by their action. So an individual or entity will be considered an ERISA fiduciary if it, number one, exercises discretionary authority or control over plan management. Those two or three words are key. Discretionary authority or control. This means that this entity, and for our discussions today, service provider, will become a fiduciary by action if it has discretionary authority over plan management or discretionary control over plan management. So this can be, and we'll give some examples later on, but such things as a service provider and who goes beyond their necessary duties and takes control and actually is running the plan instead of the plan administrator. We'll get into some examples on that. Number two, has discretionary authority in plan administration, much like we just talked about before. Number three, exercises any authority or control over the management or disposition of plan assets. Now we're talking about the money. The first two are talking about the administration and the ongoing operation of the plan. Now we're talking about money. Somebody has control or disposition over the management or disposition of the plan assets. And then finally, anyone who renders investment advice to the plan for a fee. These are fiduciaries by action. And you service providers that are listening should be looking at this going, do I fit in any of these categories? Well, let's look at some examples. The employer plan or the employer/plan sponsor serves multiple roles. Often, the employer plan sponsor will also serve as the plan administrator or the ERISA named fiduciary. As I said before, they are performing some functions, such as settlor functions, that may not make them a fiduciary for administration, but they make them a fiduciary for those actions we talked about before, the establishment and the amending and termination of the plan. But for ongoing functions, they may not be a fiduciary. However, if the employer is the plan administrator, now they're a full-fledged fiduciary. They're not just a limited fiduciary. Likewise, if they're the named fiduciary, they're taking on more roles. So the level of the employer's fiduciary responsibility depends on how many of these roles the employer is taking on. Again, what if the plan administrator is not named? ERISA says the employer becomes the plan administrator. Let's talk now about the ones that are listening today. plan service providers, and insurers. These service providers and insurers can become fiduciaries either by agreement or by function. Let's talk about a few examples on that. Let's look at an insurance carrier. If you look at a traditional insurance policy, the insurance carrier will be designated as the claims administrator or named fiduciary for deciding benefits claims and adjudicating claims and appeals. So the insurance carrier has a fiduciary function. That is plan administration at its very core. So the insurance carrier who takes these functions is a fiduciary for that purpose. What if we have a self-funded plan? Often the claims and appeals in a self-funded plan are delegated to a third-party administrator. So if we have a TPA who is exercising discretion in the payment of claims and adjudication of appeals, they're a fiduciary. Here's a big trick, though, and something you need to look at, all of you. Even if the service agreement says otherwise, historically, we saw a lot of administrative service agreements where the TPA or other service providers say, I am not now, never have been, and never will be a fiduciary. But yet I'm paying claims. So courts would come in these lawsuits and say, well, your clause which says I am not, never have been, never will be a fiduciary is wrong. By your actions, you became a fiduciary. And I'm going to throw that language out. And now you're a fiduciary for everything. They would have been better off, and most TPAs do this today, but I still see plenty that don't. It's better off to say, we agree that we're a fiduciary for payment of claims and adjudication of appeals, but not for any other purpose. Courts look at that and say, okay, that's reasonable. The saying you are not, never have been, never will be, that's not reasonable because we see what you're doing. But if you say, well, we are for this purpose, but not for anything else, court says, that sounds like that's exactly what's going on. So any other service provider might say the same thing. PBM says we're a fiduciary for purposes of benefits, claims under the pharmacy benefit. Okay, cool. But we're not for anything else. That's reasonable, okay? Now, unless the plan administrator reviews every claim payment, not just in bulk, if the claim administrator actually reviews every claim payment, they're a fiduciary for that now too. Some TPAs try to offshoot the administration and say that the plan administrator is really administering it, saying, we're sending them the claims run. They're approving it. So it's not our fiduciary responsibility, it's theirs. But we all know the truth. Even if they're sending them the daily run, the weekly run, the monthly run, whatever it is, the employer is really only looking at the bottom line. They're not looking at every single claim. That does not eliminate the TPA's fiduciary responsibility. So for all of you, look at your agreements with the clients no matter what kind of a service provider you are. I know we got a number of brokers on the call today and a number of other service providers. Even brokers who you think, well, we're just doing certain very basic functions. Even the brokers, if they're pushing too hard, if they're taking too many responsibilities, then they can become a fiduciary. We've seen in a couple of matters of litigation over the years that there have been situations where TPAs look at the employer and say, everybody at the employer is an idiot. They have no idea what they're doing on these benefit plan claims. And if we don't handle it for them and other aspects of the administration, the employers are going to get screwed by all of this scenarios. That's very honorable. They're taking over because the employer is an idiot, but they're also taking on more fiduciary responsibility by conduct, by action. And while I use carriers and TPAs in my examples, the same can apply to every single service provider on this call. Okay? Look at your contract, see what it says, and make it be exactly what you want it to be. I see we have our first poll question, Sandra. The question is, who is not a fiduciary? A fiduciary by title, a fiduciary by action, or a fiduciary by good looks? We'll let everybody answer, and it looks like it's good. Let's go on. Our next identity is parties in interest. These are fiduciaries that are subject to ERISA's prohibited transaction rules. Non-fiduciary service provider also can be subject to the prohibited transaction rules as parties in interest. These rules prohibit certain transactions. They impose requirements to fit within a prohibited transaction exemption, may be subject to civil penalties for prohibited transaction violations. There is a possible 120% penalty. If you engage in a prohibited transaction, there is a 100% penalty, and then the DOL adds an additional 20% surcharge on that penalty. And these lead to personal liability. Let me just give an example of one. Had a case with a plan that had its own plan office apart from all the employers in the plan, and the plan needed a new lease. And the executive director of the plan came to the board of trustees and said, we need to move somewhere. One of the trustees says, hey, I'm in the real estate industry. I love the plan. I've got some space I think would do real well for y'all. And because I love the plan, I will charge it at 25% below market, 25% less than I charge anybody else in the building. Trustee said, great. No problem with that, is there, Andy? I said, yeah, there is a problem. Doesn't matter if it's a good deal. Doesn't matter if it's done with the best interest at heart. This is a trustee entering into a business transaction with the plan. The trustee is a fiduciary. Any transaction between the trustee and the plan for a business purpose is a prohibited transaction unless we get a prohibited transaction exemption. They said, okay, how long does that take? And I said, usually about a year. So I had to look somewhere else to go for that. Let's talk about fiduciary highlights. Fiduciaries have special duties. Number one, the fiduciaries are held to the highest standard in the law. In most of our daily activities, we're held to the standard of a reasonable layperson, not under the fiduciary duties. We're held to the standard of a prudent professional. What are the duties? I'm going to go through these pretty fast. Duty of loyalty and exclusive benefit rule means you have the duty to act solely in the interest of participant and dependents for the exclusive purpose of providing benefits. Solely in the interest of participants and dependents. Notice participants and dependents both have an S. One of the common scenarios I get is a plan administrator, or the TPA calls and says, I got a question for you. We turned down a claim on this person. The president of the company is calling, wanting us to pay the claim. We say it's not covered in the plan. President of the company says, I don't care if it's covered or not. This person has been my secretary for 30 years, and I want you to pay the claim. That's acting in the interest of a participant, not all the participants. That's a fiduciary breach. You have to act in the interest of all participants, not any one participant. Individuals may well wear multiple different hats. You may be a company officer and a fiduciary, but when you're dealing with the plan, you wear your fiduciary hat. The duty of prudence. I spent a little time on this already. It's a duty to act with care, skill, prudence, and diligence that a prudent person acting in the similar capacity would act. Again, not the reasonable layperson. It's called the prudent person. To make it a little more clear, I call it the prudent professional. You're held to the highest standard of any person on this call. Not the most average person on this call, the most prudent person on this call. One of the fiduciary functions is the duty to monitor all service providers. We had a case at one time where the trustees got sloppy in monitoring the service providers. The service provider happened to be a TPA. When it went to court, they basically admitted they embezzled, but they said it's the trustees' fault because they didn't take any time to monitor us and effectively gave us the control to take unnecessary funds from the plan. We won, but you can still see the argument there. This duty to monitor, you need to review the service provider's performance. You need to check the actual fees charged. Now, as a fiduciary, I like to say this for my own good, you don't have to hire the cheapest. You don't have to go for the lowest bid, but you can only pay a reasonable fee. You don't just get the lowest cut rate bid of a cut rate professional, but you get a quality professional who has a reasonable fee. You need to look at all the service providers' policies and practices. You need to ensure proper maintenance of plan records and follow up on any participant complaints. Likewise, if you're a service provider and you subcontract out part of your services to a bookkeeper or somebody else, you have a duty to monitor that subcontracted entity. Duty to diversify plan assets. I brought it in here. I'm not going to talk about it. That's really a pension rule. Very few health plans are investing beyond just on-demand cash assets. This is really a retirement plan rule. Duty to abide by the plan document. You must act in accordance with the documents governing the plan. Go back to my example. I've been my secretary for 30 years. I demand that you pay the claim. Plan document says you don't. Then you don't. Now, one thing I always tell in all these talks, how do you know if you're abiding by the plan document? Read the plan document. Sounds simple, but you need to read it. I've got some clients who call and say, don't know if this claim's covered or not. And I said, well, I'll read the plan document to you. They're actually paying me to read the plan document to them. I don't mind, but that's what they're doing. Most of my clients will call and say, hey, we got this claim. This provision sounds like we should pay it. This provision sounds like it's not covered. Now we're analyzing it. That's a very different question than the first question. Fiduciary liability means personal liability. Potential liability for actions of co-fiduciaries. It includes the duty to correct if you see that a co-fiduciary has done something wrong. You cannot conceal what you found from the other fiduciaries. So if you see anybody misbehaving, you have the duty to speak up and follow up. All right, another fiduciary duty required by ERISA is having an ERISA bond. The bond must be in the amount of 10% of the plan assets or $500,000, the greater of. Most are just $500,000. The bond is a bond against mishandling of funds or by employees, internal mishandling of funds. It doesn't go to broader fiduciary responsibilities, but it is a requirement under the 1974 ERISA statute. The $500,000 limit has never been raised in all these years. For the other fiduciary coverages, look to a fiduciary liability insurance policy. Now, it's not required by the ERISA statute, but the DOL says it is a fiduciary duty to purchase fiduciary liability insurance. We go to some very large employer clients and say, let us see your fiduciary liability policy, and often they don't have one. Oh, they say, we got one on the directors and officers of the company. That's good enough, right? No. That's corporate liability fiduciary liability. This is plan fiduciary liability. It's a separate policy. The major carriers will often bundle the liability insurance with the ERISA bond, and you save on the bond and on both policies. So you can bind them together and you get savings because often the claims overlap and you don't want double coverage. But even though the bond is in the statute, the insurance is not, get both. Get both. Let's look at now some current fiduciary issues. Number one, historically, litigation under ERISA has been primarily in the pension arena. Likewise, regulation of the DOL of plans has been largely on pension plans, not health plans, historically. Why? Because there's more money there. In litigation, the plaintiffs want a solvent fund. In terms of regulation, no real secret, but regulators are given gold stars for bringing in big penalties, for finding problems that bring in big penalties. They don't get a commission or anything like that at the DOL, but they are noticed if they bring in big penalties. There is a big expansion and change here. Employees are now suing health plans, including high prescription drug costs or changes to the PBM. These claims also are looking at direct liability for excessive plan fees. As I was talking about, reasonable fees are allowed. Excessive fees create personal liability to the trustees. Fiduciaries will be better able to defend against these types of suits if they can show they reviewed available market options, compared fees and costs, and negotiated favorable terms with service providers. For the brokers online, you can help with all of that. Look at a couple of recent health claims. Lewandowski versus Johnson & Johnson. This was a class action. It alleged breach of fiduciary duties by mismanaging the plan's prescription drug benefits by the following actions: failure to adequately negotiate the PBM agreement, failure to monitor the PBM, and failure to consider alternative PBM pricing models. Now, you think, oh, okay, this is a lawsuit. Look who it's against. It's against a healthcare entity who couldn't handle and properly manage its healthcare plan. Now, the case was dismissed for lack of standing, but an appeal has been filed. I think this case is going to keep going on, but it's also just garnering a lot of attention for, if J&J isn't doing this right, what else is going on out there? The DOL recently released proposed rule to regulate PBMs, require PBMs to disclose all compensation fees paid to self-insured employer health plans. If enacted, the rule would strengthen fiduciary oversight over PBMs and plans. The DOL may rescind or revise its proposed rules due to overlapping provisions in the CAA of 2026. So this one's still a bit on hold, but it's showing the increasing heat in this area of PBMs. The effective date of this rule is down the road, January 1, 2029. This applies to both ERISA and non-ERISA plans, like governmental plans and church plans. There is a 100% pass-through of rebates, fees, discounts, and compensation of the plan. Requires drug level reporting and plan summary reporting from the PBM. It requires an annual notice and plan level summaries to participants upon request. And look at this number, $10,000 per day for non-compliance. This will be a big deal as we see how it develops. Interestingly, now, talking to brokers here, you're often doing, giving great advice on the health plans and particularly the major medical plan. And they may also have a dental plan, a vision plan, and now you also have voluntary benefits. And Many of the voluntary benefit carriers will say, we're not ERISA plan. Nearly all the time, that's not true, whether they say it or not. Voluntary benefits absolutely are ERISA plans, except in the most extreme examples. I won't go in that test. It usually takes me 30 minutes to walk through that test on how they become an ERISA plan. Let's just say for today that they are ERISA plans. There have been several class actions lawsuits recently filed targeting employers and their employer broker consultants for alleged breach of fiduciary duties related to voluntary benefit plans. This case has really shaken up the legal field and the market. The claim is the employers failed to ensure that the costs of these programs are reasonable and caused employees to pay excessive premiums. What do we mean by this? It means that they saw that either the claims were too small a number of the total costs, or from the inverse, that the margins were too big for a fiduciary covered plan. We got the Brom case and the Brewer case and the Pym case. The plaintiffs allege that the brokers, we got a bunch online, brokers are plan fiduciaries who violated their fiduciary duties and engaged in unlawful self-dealing. So this is a new warning sign to all the brokers in our industry. Proactive options and actions. Monitor and negotiate premiums and compensation. Ensure reasonable commissions and prudent carrier selection. Maintain a meaningful process for selecting and monitoring carriers. Conduct a competitive market check. Okay? EBSA, which is under DOL, lists the national enforcement projects. They're looking at cybersecurity, barriers to mental health and substance use disorder benefits, protecting benefit distributions, retirement asset management, surprise medical billing, and criminal abuse of contributory benefit plans. Let's talk about cybersecurity for a moment. Our industry is particularly vulnerable to cyber attacks. Of all industries, we are the second most valuable data. The most valuable data is in the merger and acquisition securities arena. If you can get in there, you're getting behind the scenes information. You can go buy stocks knowing that a company's about to be bought or sold or whatever. Number two is healthcare PHI, because the penalties are so extreme. There's been a recent surge in ransomware attack and breaches prompted by oversight from various departments at both the federal and state levels. We've had to work with clients that have gone through this. Ransomware is particularly awful. We've seen cases where a client would have to pay the ransomware criminal agency to get a password to get their data back. And then once they paid the agency, they get an email from an employee at that agency saying, okay, you paid my boss, now you got to pay me too, because there are two passwords on this account. As of December 31, 2025, almost 57 million individuals are known to have been affected by breaches in 25. The DOL historically has considered prudent cybersecurity practices and HIPAA compliance to be fiduciary duties. Penalties for failure to comply with these rules are steep, and I believe we now have a polling question, which is not a fiduciary duty: cybersecurity, HIPAA compliance, or the company fantasy football league. All right. There we go. There are, hey, 100% got it right. Although, there could be some data in there that might be of value. Who knows? All right. Self-funded plan has been hit by enforcement action under HIPAA. We have a recent enforcement action agreement against an employee self-funded plan. The OCR found that the plan failed to conduct an accurate and thorough analysis to determine potential risk and vulnerable to its EPHI. The employer had a ransomware attack. Over 9,000 individual lives were affected, and we had a $250,000 penalty and a requirement to follow a corrective action plan. This brings about something I want to say. This was an OCR action. The new administration is known for relaxing enforcement in a lot of areas. They're not relaxing it under HIPAA. This administration is very stern on privacy. So if anything, they're increasing enforcement under HIPAA. Remember, the scope of EBSA guidance is broader than the privacy and security rules under HIPAA. Even if health plans are compliant with HIPAA, plan sponsors and fiduciaries must take additional steps to comply. Another issue can be the inadvertent creation of a MIWA as a fiduciary breach. Companies today increasingly are looking at mergers and acquisitions as a growth engine. Often, when a company might be just an employer adding a new subsidiary, might be a private equity company buying more entities, that often can create a multiple employer welfare arrangement. The intent is irrelevant. This comes about because the entities may not be part of a control group. They become a MIWA, and they have issues then because, number one, they haven't been filing as a MIWA. They haven't filed a late form, or their Form M1, for which the penalty is nearly $2,000 per day, though there has been recent relaxation. So if any of you know of an inadvertent MIWA, reach out, because you need to look at that, this relaxation. We don't know how long it will last, but it's a single penalty instead of the $2,000 a day penalty. And it's a very good time to correct now, because maybe next year, maybe when we have a change of administration down the road, that easily could go away and we may be back to the $2,000 a day penalty. You also need to correct an incorrect 5500. You may have said that you have a single employer plan when actually it's a MIWA. And you can have state regulatory issues, particularly if it's a self-funded plan, because the states treat self-funded MIWAs the same as insurance carriers. And you have to file for licensures. And if you don't file for licensures, the state can shut down your plan. So let's look at the action items here, particularly under HIPAA. Number one, document your efforts. Under HIPAA, you need policies and procedures. OCR is very clear. If you haven't done a risk analysis, but have only done policies and procedures, the policies and procedures are worthless. You're not addressing your own company's situation. You need to review the DOL cybersecurity guidance. In the risk analysis, now the risk analysis, particularly for large employers, are very difficult to do. And we work with a number of them in doing that. But we also, like for small and medium-sized employers, it's really hard to pay the fee for some firms in doing a risk analysis. OCR came out with a new risk analysis called an SRA. It's a portal online, and it's a security risk analysis portal. Your client, the employer, inputs the data. It'll take a while, but at the end of the input, it gives that employer plan a score. And if the score isn't good enough, they need to go back and correct some things. Or at that point, bring it to the lawyer to work on policies and to work on corrections. OCR assures us that they don't see what's input. They're not using it to find folks who are non-compliant. I went through the training session. I will say the SRA is an excellent tool. I highly recommend it to you. I recommend it to you to recommend to your clients. Again, it's the OCR HIPAA security risk assessment. Make sure your privacy and security policies are up to date. Review internal cybersecurity policies. Monitor service providers and review breach notification policies. Review your vendor contracts, especially on that provision I was talking to you about. Are you or are you not a fiduciary? For you service providers, the best thing you can do is to say, I am a fiduciary for this purpose and this purpose only and not any other purpose. That's good. That's good for you. It's good for the employer. Currently, understand how AI is being used by service providers. Do they have machine learning as opposed to AI? Are they using open source AI? Plans shouldn't be doing that because we don't want that plan information shared. That could be a HIPAA breach. Look at how AI is being used, both in terms of administration of the plan and the protection of PHI. Practice online safety and educate participants. Key takeaways. While all the activity in this area for years was with pension plans, not health plans are now in the news. In my own personal situation, I always thought I was kind of in this little enclave among lawyers, of employee benefit lawyers, that even other lawyers didn't know that there was such a thing as an employee benefit lawyer. When the ACA came about, everything changed. All of a sudden, what we do was on the front page of the news every day. And we're being interviewed by various news publishers, TVs, radios. One of my highlights was I got interviewed by Wall Street Journal, an article that was on the front page of the paper. When I came out of law school, that was about the last thing I ever thought would happen to me. But I will admit it was pretty cool. Your fiduciary duties are more important now than ever. This next one is key. Document everything you do. Now, you think, oh, hey, I remember everything. I got good files. I got a good file and system in my head. But what if something happens to you? What if you're gone? What if you're disabled? What if you get a better job? Protect the employer when you leave. Document everything you do. And if you get audited, what you did, you documented what you did. And you can prove that you were fiduciarily responsible. Stay informed. Keep attending EBPA seminars. Go to other sessions. Go to other symposiums. Take a nice trip somewhere. I just got back from a nice trip in San Diego where I was able to teach. But go to sessions. Learn about this. And keep you and your clients safe under ERISA fiduciary duties. I will stop there. I don't know if we got any questions. I see we have about 5 minutes left. I actually went 5 minutes over on what I was supposed to do, but we still have 5 minutes left. Andrew, Sandra, do we have any questions?
No questions. If there are any questions, feel free to put them in the Q&A portion, and we can get those answered before the top of the hour. I want to pass along a quick reminder before I let Andy sign off that there's a in-person breakfast coming up in preparation for Q4. Emily Laning is going to be talking about ownership, accountability, and purpose, and it's going to be focused around communication practices and best practices, and that's Wednesday, September 16th in at Melbourne Country Club, and that'll be for CE credit as well. And it looks like we have a question, but it's just John Ritter saying, "Nice job, Andy." So kudos, Andy. And I will pass it along to Andy for sign off.
Well, thanks, Andrew, and I really appreciate it. I appreciate how many we had here today. If you have a question you can't think of now, send it to EBPA to send to me. Or my email address is simple. It's Haynes@haynesbenefits.com.
Thank you, everyone.